All right, good morning, everyone.
May it please the court, I
Yes.
apologize for interrupting, but may Senator Gardner sit up here? He can hear better if he sits up here.
Is there objection from any side? That's fine.
Thank you, Your Honor.
All right, if you will give me just a moment to pull up. I would like to introduce my amazing interns here in Chancery Court Part 3. We always have delightful interns that come and participate with us. And this semester, we have Alicia Van Hoosen, and Alicia actually was with me this summer and continued on. She is a 2L at Belmont Law Review and has been just such a wonderful asset to our office. And then we also have Andreas Martinez, who is also a 2L at Belmont and Law Review. Andreas will be continuing on to Bassberry and Sims, is that correct? This summer. So we are just so delighted to have them with us. And I haven't seen you all in quite some time, so Happy New Year. And we will get started. First, I'd like to have a bit of a conversation in regards to scheduling. And, you know, maybe we want to keep that at the end, frankly, and kind of get through whether or not we are going to, let's talk about the log first. And then we'll get to scheduling this matter for this show cause. And frankly, since so much time has passed, you know, this may be a restart now that we know who the parties are. But I will hear from Mr. Pierce.
Yes, Your Honor.
Yes, give me just a moment. We will also get just into a few logistics in regards to how we will move forward after I hear from Mr. Pierce, but make sure that I've got the right slide. Okay.
May it please the court, this is Petitioner Brewer's motion to remove the restrictions on the privilege log, which this court first made reference to and ordered that Metro produce in this court's order of May the 4th, 2023. At that time, the court directed Metro to produce the documents that had been requested pursuant to this Public Records Act case by the petitioners then in the case, and produced just for an in-camera review, but also that there be a privilege log prepared by Metro that would be produced, but for counsel's eyes only. So therefore, I saw, and the other counsel for petitioners saw the privilege log, but it was subject to a counsel eyes only restriction. And then sometime later, it became obvious that Metro could only produce the documents a little at a time. They did produce some documents with that privilege log which Your Honor had requested, and we got the privilege log, but that was not all of the documents. When we were here at another time, I inquired about the status of the production. At that point, Metro pointed out that it would, in their opinion, made more sense for you to come to police headquarters to look at the documents, review them there. And at that time, I understood that that's what the court was going to do. You entered an order to that effect and said that there would be also prepared by Metro an Excel index to assist you in review of those documents.
Yes, and my order also said that that was to remain, not to leave the Metropolitan Police Department, and was just there to assist me as I was going through the documents.
Yes, and as far as I know, that's what has happened. And our motion here is simply to remove the restrictions that apply to the privilege log, which was the first part of the order that you had going back to May the 4th. And the reason that we request that those restrictions be removed is that although the court may have anticipated there would have been something confidential in the log itself, in fact, there is nothing confidential in the log. Further, there is a common law presumption that court filings will be open to the public. And finally, the nature of the items identified in that log are such that it becomes very awkward, and I'm not sure how the court would handle us being able to discuss those items that are in that log as we move forward with the case.
Well, Mr. Pierce, so that log was never filed with the court. So it was simply, and let me give a little context to, of course, when this case first started, it was right after the events had transpired, and it was kind of this mad dash to the show cause hearing. And so I was thinking about ways to kind of parse through the information in an orderly manner. But that log is not a record in this court. So when you speak about open records, can you help me understand why a log that is counsel only, between counsel in this case, is subject to any open record, TRPA, anything? Because it's frankly, I don't view it as a record of the court. So can you help me?
Well, certainly, Your Honor. I've cited a number of cases, and the point is those documents are often appearing to the court in the same fashion that that privilege log has appeared before you in this case. It doesn't matter. As long as it's made available to Your Honor, then it should be made public, unless there is some specific reason when it should not be made public. Whether it gets filed in the clerk's office or merely placed in your office does not change the common law presumption.
Okay. Can I have counsel approach, Ms. Fox?
No, I didn't. Oh, okay. I'm having a hard time hearing everything we're talking about. Are you talking about the Excel index?
No, the original blog. I think it was before you went to the headquarters.
Oh, yes. I mean, I have a copy of it. I've marked mine up. I don't know if you need to see that right now.
I thought that was my recollection, yes. Well, I'll have to check that. Yes.
Well, let me look.
I can certainly email one now, and I don't have one for example.
It's okay, but before. So did you ever just look at the declarations?
Sorry, I couldn't hear you.
The declarations.
Of who?
Did I put your notice of filing?
Something to that effect, yes. Yes, I believe that's a yes.
Yeah.
May 12 was the date that we introduced the law, stating that the 2 flash drives are hereby provided to the court.
Drives, but there was no
Yeah. Okay.
So, and of course nothing was filed.
Well, let me, shall I send it to you now? Or send it to someone now? Is that, I'm not sure what to do.
Well, I want to point out, this is the one right here, and it does say, this log has been filed in the Chancery
This has
Court.
not.
It's not been filed in the Chancery Court.
But I thought we would have put it in there.
Well, that would just kick out that argument I'm making about the common law presumption. It doesn't change the fact there's nothing confidential, and we need this to talk about the documents.
Okay, I'll let you continue to make your argument. I'll let you continue to make your argument, and I'll hear the rebuttal. But I also think that there's a way to address it. So, but
Sure.
all right.
Thank you.
If you want me to send something to a clerk, I could do that now. So you can look at it if you want to look at it now. It's only a page or something.
I'm sorry.
Depending on what happens at the end,
Well, if you haven't seen it, I was under the impression that I'd seen, and one of our big points is that, see, the 5th bullet point down is that there's this one document.
so why don't we, so why don't we, because my order is separate than the case between council. So I just wanted to make you all aware that it is not in the purview of the court before
Okay.
I came out for recording. Okay, so,
Very well.
and you can pivot, I didn't want you to be surprised. But I also wanted you all to know that it's just not,
Sure.
I've never
Well, we'll finish this.
Thank you.
then.
Thank you, Your Honor. Yeah, I understand that you have not seen the log, other than the extent that I may have shown it to you just a second ago. And therefore, to whatever extent my argument concerning the judicial presumption of, the common law presumption of open records may not apply. But beside that, if we throw that argument out the door, there's still nothing confidential in the log. Metro does, I've made that clear in my motion. Metro has not disagreed with that point. And that is the very purpose of a privilege log, is to allow the parties to discuss the general nature of the documents without revealing the documents.
Right, but when we think about a privilege log in its traditional sense, which has what has happened in this court, they aren't filed with the court. They truly are for the benefit of counsel during the discovery process.
Yeah.
And typically, discovery is not filed with the court and then does not, become open. And so when we think about this log, how it has been presented in this case, it is between counsel. Now, what I do have is the documentation and the information that I requested so that I could prepare for the show cause, but making a privilege log open to the public when it is not a record of the court. I don't understand how we get there, because it's not a record here. It's not even in camera review. It is between counsel, which is typical. You know, when we think about discovery, counsel typically keep things confidential. They then exchange privilege logs, and counsel have a conversation. So that is that's a big factor when it comes to releasing a log that this court does not have within its purview.
Well, what I would say is that it is difficult for me to make use of that log if I cannot even show it to my client. As you know, I'm representing someone who's working with the National Police Association.
Mm-hmm.
They have a great deal of experience dealing with law enforcement that I do not have, and I would like to be able to share that with my client so that I can get the benefit of what they can provide to me, so that I can adequately represent their interests in this matter. That's one area.
Now, one question that I do have, if you can help me, when we think about FOIA requests in their traditional sense, a FOIA request typically is limited to what the parties have requested at the time. And if they are seeking additional information, do not they have to file an additional request?
That may be true, certainly, Your Honor. I'm not sure how that applies here, though.
So your clients, when you think about preparing for the show cause hearing, aren't your clients going to be limited to the documents and information they requested from Metro when they did the original open records request?
Well, they're limited in this case to litigating access to those documents.
To those documents that they have already identified that they want, correct?
Yes.
So help me understand your inability to discuss with your clients the information that they have asked for.
Well, the log and the documents we request are the same thing. That's what Metro says. The Metro says that this is a log of the documents we have requested. And so this log will help us understand what it is Metro is holding that we have requested.
And you have viewed the log, correct?
I have viewed the log. Okay,
and are you saying that you cannot adequately explain to your clients what you have viewed on the log?
Well, I have tried very hard to err on the side of being confidential about this document. And that brings us to another point. I pointed out before, and again in my motion, there is currently a proceeding in another court in this courtroom, a probate proceeding that is inconsistent with one of the documents that is on this log. And
But I don't have jurisdiction over that probate matter, is that correct?
Not that I'm aware of.
Right,
But there is a fellow judge in this courtroom that would like to know what... I mean, we had Mr. Rabin stand up in your courtroom, Your Honor, and say that the shooter died intestate. And that is inconsistent with what Metro has told us.
But that's not my case. So, and I don't believe that your client in their original FOIA request, which I have pulled up here, your client was very detailed in the records that she requested. And so I'm not quite sure why the goings-on of what's happening in probate court have anything to do with what your client has requested. Now, if your client is wanting additional information, then the onus is on your client to do an additional open records request, because your client set forth a very detailed list, and I actually appreciate your client's list versus just a broad swath. Your client gave 9 things that she was interested in. And so when I look at the 9 things that she requested, they have absolutely nothing to do with probate. And frankly, when this court goes to look at the records that are at issue in this case, I am hemmed in by what your clients have requested.
And we requested the writings of the shooter, and this is one of the writings of the shooter, this fifth item that's on the list, which I can state openly now if I understand from the, and I'm happy to do that. I just
Well,
want to make sure
hold
I'm
on. So section 2 of your client's request was all writings to include a manifesto of Aiden Hale recovered by the Metropolitan Nashville Police Department relating to March 27, 2023. So your client made a surgical request.
Yes.
She wanted the writings recovered by Metropolitan Nashville Police relating to the March 27, 2023 incident. So to me, there's not a question about whether or not it's on privilege log, whether or not it's not on privilege log. At this point in time, we really are hemmed in, and that's for all of the petitioners at this point. All of the petitioners are able to file additional open records requests, but when I look at what they have requested, I'm actually looking at your request, and my job is to understand what Metro does not want to provide and then make a determination of whether or not those documents are open records or not. So I still don't understand why the privilege log needs to be made public at this point, but happy to continue you explaining to me, because I need you to thread the needle a little bit more.
Well, I want to make sure that I understand your original order and what you meant by council eyes only. Am I now free to state in open court these particular items that are listed on the privilege log exactly the way Metro has stated them, or am I prohibited from doing that?
So I don't know what is on the privilege log, so I am kind of at a disadvantage. Perhaps, council are able to work together and come to some kind of agreement in regards to the privilege log. But, and this kind of gets into the next phase of kind of how I thought that this should go in regards to argument, because I think that that's truly what you're getting at. You want to know what questions you can ask, what documents we're talking about, and how you're going to present to me whether or not, Metro is keeping this under, not giving it to you, or if they are. And if you can't mention the document, you're concerned that you're going to run afoul of this court's order.
Well, number one, yes, we'd run afoul of it, and number two, we can't present our case. I mean, we're told the information, but then we're told we can't use it.
Okay. Is there anything else?
I would take it one step further to say that when you issued your original May 4th order, it seemed to indicate that Metro would produce all of the documents requested, and there would be a privilege log for all of those documents. But that's not the way things developed. As I mentioned earlier, and as Your Honor knows, there later became a time when Metro said, well, it made more sense for you to come review the documents, but that they would prepare the Excel index. I understand the Excel index is the same as the privilege log, except that we've been given a copy of the privilege log. We've not been given a copy of the Excel index, and so I'm requesting that we also at least get a copy of the Excel index. And if Your Honor feels that it should not be made public, then it too should be subject to the council eyes only. But we should get that.
And also just for clarity, the court doesn't have a copy of the Excel index either, right? Because my order specifically said that the Excel index should remain with MNPD, and I would view it at the time that I went to go and look at the documents at issue. But we're going to, get to all of that as I have become reacquainted with this case after its hiatus. We're going to get to, frankly, the requests that are at issue in this matter and how we need to move forward. But I understand that you were also requesting the Excel spreadsheet. Is that correct?
Yes, Your Honor, for the very same reason that we were afforded the opportunity to look at the privilege law.
Okay,
Thank you, Your Honor.
thank you. Ms. Fox?
May it please the court, I'm Laura Fox from the Metropolitan Government. Your Honor, Metro is not trying to hide the ball in terms of what's in that file at all. I think that the log is a sort of breakdown of what they've really requested, which is the investigative file. And but what I would suggest in these circumstances is that the attorneys just get together and work on a universe of categories that we can brief. I mean, there's been briefing for the court already.
But it may be stale.
It may be stale. I'm not sure ours is, but we're happy to update it, of
Sure.
course. But I think that if the attorneys get together, we can come to an agreement on the categories that we need to brief. I think the alternative is, since you have viewed the file and you may wish to come view what has been done since, you could categorize them and tell us what issues you would like briefed.
So
I think either one of those would be fair to everyone.
So just in all candor, when this case first started, there was kind of a mad dash to attempt to get the universe of information. But when this case went up on appeal, I had other cases. And so I have not done a deep dive. And to be honest, as I look closely at the FOIA requests, and when this case kind of first came in, there was a lot of information that was set out for me to review. And frankly, I don't know that all of that information was requested in the FOIA request. And so for me, Metro or MNPD, you all need to tell me the universe of documents versus me going in and looking at a whole bunch of documents that may or may not be responsive to a particular FOIA request. I just think that the onus is on the entity that is denying access versus on the court to determine whether or not access should be given. You know, access was denied for a particular reason, and whatever that universe of documents is, now if I have that and it's all of that information, I just need someone to tell me that it's all of that. But I do believe that the universe that I am dealing in is a very big universe, and perhaps it's a little bit narrower, but perhaps not. And I think that it's very important when we look at the FOIA requests by each of the petitioners, you know, and there's an attorney's fee, you know, penalty basically in cases like these. And so we're looking at a moment in time, because you can't be held accountable for not complying with a FOIA request now for new information that wasn't asked, that you weren't asked for, right? And so for me, when I'm looking through, you know, and I will use Ms. Brewer's request was very detailed and helpful to the court when I go to analyze the documents, you know, but Ms. Brewer's request was done back in April, right? And so at that time, that's the universe that we're dealing with, you know? So this is for all counsel as we're moving forward in this case, which we'll kind of get to the logistics, I guess, now, because it's a natural segue, unless Ms. Fox, you have anything that you want to tell the court? Okay. When we think about this case and moving forward and the information that the court currently has, I need Metro to tell me what documents they believe are responsive and why they are not producing them. That way I can then go in and look. Right now I have a whole bunch of information, and honestly what was presented to me was a room full of information, literally. And so if I have everything as of the date of the request and nothing needs to be updated, that's fine. But I kind of need to know what universe I'm looking at, you know, versus, and you all have done this before, so I would imagine that you're not leaning on the court to go in and look at all of the documents, but it's narrowly tailored to what was requested. Am I incorrect in that, Ms. Fox?
I think that's correct, although the investigative file, I think, has broadly been requested, and that has a lot of things. But if the court wants us to break that down so that it can be more easily briefed, I certainly understand that.
Okay, and the investigative file, was that requested by Star Media? Or was that by Mr. Hammond?
I don't know off the top of my head.
Okay. All right. Is there anything else?
No, Your Honor.
Okay. Mr. Pierce, do you have rebuttal?
I'll just keep it to myself. That'll be fine.
Are you sure?
Yes.
Okay. All right. So I am going to order counsel to see if they can work together on the documents that are, at least the privilege log documents. And those are not before the court, you know, so I do not want a filing. I don't want a notice of filing. I just expect counsel to work together so that they can prepare for this case. When I look and think about the argument of this case, and I think about, in Ms. Brewer's petition, I will use that as an example because she has 9 different bullet points that she is looking for. Mr. Pierce, in the court's opinion, you can argue the matters, you know, before the court and the documents because you know what your client is asking for. And Metro should be able to address each of the categories of documents as to whether or not there is an exception or not, because it's laid out. For the other parties who have asked for a more broad swath, and I believe that that is going to be Mr. Hammond. Hold on, let me make sure that I am correct. So even when I'm looking at Tennessee Firearms, they were specific. I believe it was Mr. Hammond who asked for a broader swath of information. And then I do not have, which would be helpful, I do not have the actual FOIA requests from Star Media or from the Tennessean. And so for those counsel for those parties here today?
Here for the Tennessean.
Okay.
Yes, sir.
All right. So I know that the statute requires you to file the denial, but it is helpful to the court to know the documents that you're asking for. And I just don't have those. I don't have your FOIA requests. So the court would ask each of you to file the actual FOIA request under a notice of filing so that I know what you're talking about. Okay? I have that for Ms. Brewer, Mr. Hammond. The National Police Association, I have a FOIA request for them, but I'm not sure that there's any counsel in this case for them. Who represents them?
Yeah, they're working with Ms. Brewer.
Okay.
Ms. Brewer's working with them.
Okay. All right. And then I have Star Media, Tennessean, which is also Senator Gardhire and everyone there. I don't have those, you know, specific requests as well. So if you could just, if there's a notice of filing that you could file with the specific FOIA request so that I know exactly what you're looking for.
Yes, Your Honor. In fact, when we did the appeal, those documents are in the appellate record, but certainly we'll be happy to file a duplicate of those
Okay, because when I was looking at the complaint and the attachments there too, I did not see the actual FOIA request. Are you telling me that they're in there attached to the complaint?
Your Honor, I was not here.
Okay.
I'm a latecomer
Okay.
to this proceeding.
Sure.
But it's my understanding that the FOIA requests have been filed, but I will verify that, Your Honor, and believe me, they will be filed.
Okay, because we were looking for them, because I have a folder with everyone's FOIA requests, and I just don't have the actual request, and I'm looking again at Exhibit 2. I have a description and a date of the request, but I don't have the actual paper. So
I assumed that they had been made part of the record by making them an attachment to the complaint of Tennessee and Senator Gordon Iredell. If they were not, I will certainly rectify that situation immediately.
okay, thank you. So if you haven't filed to council, if you haven't filed your actual FOIA request, please do that under a notice of filing. I also think that it will help narrow the universe of documents in this case. So that is my ruling in regards to the privilege log. Again, it's not a record of the court at this point in time, and so I am not going to release the privilege log. I do want council to work together, and based on your FOIA request, that, Mr. Pierce, those are the documents that your client is looking for. I have another open records request, and I understand perhaps the slight disadvantage that you have when you are petitioning the court for relief to get a record open that is not open. But right now, they aren't open. And so until I make a ruling on what should be open and what should be not, the statute is written how the statute is written. And I'm not going to rewrite it here today. All right, so in regards to dates, because that's the second matter here, is the date of the show cause hearing. Happy to have just a discussion on what will work for everyone, any additional briefing since you all were here last. I will tell you, I have back-to-back trials. One of them is a 2-week trial, so February does not look good. And as I'm looking into March, there is some room in March. However, I have a 2-week trial right at the beginning, and yeah. So let's talk about scheduling. Now that we have all of the parties, is there any additional briefing that needs to be done?
Well, Your Honor, your last order that you had before the Court of Appeals issued a stay had a number of deadlines, including the show cause hearing. Some of the deadlines have been met, some have not been met. But of course, Your Honor just said that maybe some of this is now stale.
Well, that's just me, but I don't have any information from anyone. So
I would say I would add this, and I'm sure you're aware of it, just from living here in the community. You know, we had a big development, and that was a leak of several documents.
that did not come from my court.
I think that's excellent, and it didn't come from me either. But that may require some briefing. The only thing I would point out is when the Court of Appeals issued that stay, the deadlines that were existing with Mr. Hollow, he still had time to file on his client's behalf. Metro had time to file on their behalf, and And then you said, and if there's any other declarations that need to be filed, I think you had a June 20 deadline. But those were the unexpired deadlines.
Okay. Let me pull up my last scheduling order in this matter. So originally, we were working up to a June 8th, 2023 show cause hearing with deadlines at the end of May and beginning of June, and then the close of briefing on June the 5th. That's the last scheduling order I am seeing. So, and I will hear from each council to tell me where, except for the interveners, because I know you all were not a part. Were you a part? You were a part at that point in time. Okay. So, respondent, do you have additional briefing that you believe that you need to do?
No, Your Honor, but we would probably like to respond to what they need.
Okay.
So I was going to suggest that maybe if we picked a date for the show cause, we could work backwards.
Okay, I'm fine with that.
Was what I was thinking.
All right. Is everyone in agreement with that? Okay, so March, how is everything, and I am very sensitive in regards to March. I'm happy to move it to April if you all would prefer. So can I just get a general consensus on that? Because I will tell you all, before you get started, I still have to prep for this case, and I'm in trial the first 2 weeks of March on a very litigious issue, and then there's judicial conference, and then the next week I have 2 administrative hearings, and that is around the anniversary of the event. And so the court would prefer to stay away from the anniversary of the event.
May it please the court, we would be very happy to talk about April
Okay.
as a time for show cause. It seems like that would work best for the court and would give us an opportunity to get everything briefed.
Do I hear any objection?
April's very good.
No objection.
Mr. Pierce has an objection, I think.
Anytime in March is great for me, Your Honor.
Okay.
I'm fine March as well, but I understand the concerns.
April will be fine, Your Honor.
April is fine, Your Honor.
Okay, well, I have a general consensus for April, so we will move to April, and let's look at the April calendar. So I am in a jury trial beginning April 8th. The week of April 15th looks open. The following week looks open, and then I'm in trial again at the end of April. So,
Your Honor, if I may.
yes.
Eric Osborne for the Interveners and Covenant School Families. I currently am scheduled to be along with some colleagues, in a federal criminal jury trial starting April 5th. It's supposed to run 3 weeks now. Your Honor, I don't know if I myself will necessarily need to be there all 3 of those weeks because there are other counsel with me, so it's not impossible to work out something in that April 5 to April 26 range, but my own personal preference would either be the first week of April or after that trial is concluded. But again, Your Honor, I'm very happy to report around that because I'm not the only counsel involved in that case.
So the last week of April, the court has, or sorry, not the last week of April, the last week of March, I have a couple of administrative appeals. That's also, I have that as Good Friday week, but maybe I'm wrong on that.
And as
Okay.
you said, Your Honor, that's also the anniversary of the
Mhm.
event. Yeah.
So that first week, do I hear anything from anyone else in regards to potential either the first week, the 15th, or perhaps the week of the 22nd?
You know,
Yes.
for the Covenant Presbyterian Church, Rocky King, we can make April 1 through 5, any of those respective days.
Okay.
Your Honor.
And Your Honor, if I may, by April 22nd, there's a good chance my other trial will be done, so that might be a preferred week if that's possible, if that works for other counsel. But again, I appreciate that there's a lot of us trying to line up here, so thank you.
Okay. Mr. Pierce, the petitioners, anyone?
Worse, the week of April the 5th works very well for us, Your Honor.
So April 5th is on a Friday, so are you
Well,
mean?
mentioned, I think it probably April 1st through the 5th. Is that what Your Honor is speaking of?
So that first week, coming off of Easter break,
Yes.
that first week looks available, except for Tuesday, and then of course Friday.
We're good that week.
Okay. Anyone else?
We're also very good for the week of the 15th. That's a wide open
Okay.
for us.
That week is what?
I understand, counsel, that's a problem.
Sure. That week is wide. The week of April 15th is wide open for the court as well, with no other hearings except for my normal Friday docket. So I'll hear from the other petitioners.
Your Honor, John Harris for Sheriff Hammond and the Tennessee Firearms Association. We'll do any time in that.
Okay. Is that the general consensus?
Your Honor, general consensus here, anytime in April. So.
Okay. Do I have any objection to any date that I choose in April?
No, Your Honor.
Okay. Why don't we then, Mr. Osborne, you're saying you're not at all available April 15th?
No, Your Honor, it's just that I am involved in a team that's going to trial at the beginning of April. But as I said, I'm not the only person on that team, so I can come and be here for this at whatever date the court prefers. You know, I think the 15th may be preferable to meet in the first week because the first week is when we would be doing voir dire. But
Sure.
I think it's important for counsel to try to be there the first couple days, but it's a 3-week trial with lots of counsel, so my ability to step out to be here for this is pretty open.
Okay. Why don't we do April 16th? Okay, Tuesday, April 16th. Or would you all prefer Wednesday, April 17th? I have both days.
16th, Your Honor.
Okay.
May it please the court, I believe earlier the court has scheduled 2 days for a show cause hearing.
All right, well, we can have April 16th and 17th.
That would work for us. I just suggested that because I believe from a previous order, I read where there were 2 days scheduled for the show cause.
Okay.
Your Honor?
Yes.
As far as those dates are fine, I just wanted to mention that you entered an order on May 26th about live testimony and said that you probably weren't going to allow it. And so I guess we just need to clarify that timely before the hearing. Without live testimony, I'm not sure why 2 days would be necessary, but
Okay. Let me look at my order. So typically, of course, any request for live testimony is done via motion, because typically in these cases there isn't live testimony. Are we wanting to discuss that, Mr. Osborne, and I said that the court will leave open the possibility of live testimony in order to provide proof or evidence that is probative. So,
Your Honor, I don't believe live testimony should be necessary. The parents provided testimony in the form of declarations instead to this court, and so that should be sufficient unless, of course, Your Honor wishes to hear from people directly, in which case we're happy to try to facilitate that. But I think the parents prefer to provide their testimony via written declaration given the emotional sensitivities.
of course.
So, thank you.
All right. From the petitioners, anyone care about live testimony?
No, Your Honor.
Okay. All right, so if live testimony is not an issue, we'll reserve the 17th just in case we need it, but we may be able to finish on the 16th. Let's start at 10 a.m. And we'll just go until we're done. So when we think about presentment in this case, so the petitioners, you all there are certain things that you all want, right? And then you all kind of diverge on other things. And so there are able attorneys on the petitioner's side to kind of figure out if you all are going to come together and have some synergies, or how we're going to argue this with so many petitioners requesting different things. So I would hope that you all can work together on that, but I will hear from counsel on kind of what your thoughts are in regards to the differing things that you all are requesting.
Please, Court.
Yes.
Certainly would like to thank the court for those comments. In reviewing the case, which I did in order to file the pleading, which I filed on Friday.
Yes, I saw your pleading on Friday. Now, I will tell you I didn't read it because we were just here on a narrow issue today.
I understand. But in reviewing the requests as they appeared to me in the record, we have three petitioners who are essentially asking for the same thing. And that I would sort of categorize as the writings of the shooter. The material generated by the shooter, whether it be her diaries, her notes, her manifesto, whatever they happen to be called. But Senator Gardenhire, the Tennessean, and I think Ms. Brewer, their requests all fall in the category that would be covered by the generic term, the records of the shooter as obtained by Metro Nashville and part of their investigation and their processing of the search warrant materials. Then we get into the fourth request and the fourth and fifth request for the digital media and then the Firearms Dealers Association, and those are very much more detailed. At least that's the way it appeared to me in reviewing the record. And may it please the court also, when I looked at the Court of Appeals opinion, the Court of Appeals opinion appeared to be summarizing the issues that were before any tribunal, I guess, that were sort of there with respect to the requests and the defenses that were going to be applied to those requests. And it appeared that there were about 4 categories there as well. And I was just thinking in terms, may it please the court, judicial economy, and I think Your Honor can appreciate that we narrow down what we're really arguing about. And as part of that process of winnowing down, we need to decide or to be aware issues about the confidentiality of school procedures for handling mass shooter situations. There are issues involving the Victims' Rights Amendment have been asserted on behalf of the intervenors. And then, of course, we have the Rule 16, which kind of is the brooding demon that hangs over everybody in cases like that. And so, what I wanted to do, please, it's not about me. It's about the convenience of the court. And what I hope we could do would be to say, okay, these are the issues that really matter. It's a matter of law. These are the ones that really matter. These are the things that we're looking for that really matter. And then that would help us in our briefing, and it would also help us in narrowing the issues and making it easier for the court to receive our presentations.
Okay, so you're thinking 3 broad categories of the writing, or the writings are when I think of this case, I think that there's one piece, of course, that the petitioners are primarily interested in. Those are the writings.
Yes,
Okay.
I think Your Honor is correct.
Okay. And so, but then we do have these kind of, we also have these outliers who are requesting different things. So when I think of, and without having the benefit of Star Media,
Your Honor, just to clarify, our
yeah.
requests are in our complaint, paragraph 6 and paragraph 8, so it's there.
I've seen it, but I would like to actually see.
Sure, I'm just letting you
The
know
request.
that's the total request.
Okay.
So it's going to be a form with that paragraph in the middle of it signed and submitted to Metro. It's
Okay.
not additional information, so.
Well, and again, it's hard for the court, when I have FOIA requests from everyone else and then I have complaints from others, just to make sure that everyone's on the same
I'm happy
page.
to file it, I was just letting you know. It's
Yeah, I'm aware. And then Mr. Hammond, who represents Mr. Hammond? Mr. Harris. Yes, so Mr. Hammond seems to have the broadest request in the court's opinion. And so are you going to, should I view his request kind of as a standalone and you will just argue on behalf of your client for what your client is looking for? If we're coming out of these broad categories, your client has some specific things that he is looking for, and do you plan on just arguing those as a standalone?
We'll argue separately, Your Honor, ancillary to the 4 topics that Tennessean has brought up. But we will also revisit those in our briefing to see if we might narrow them.
Okay. I think that would be good for all parties, as we have kind of, this case has settled a little bit. We've had some time to maybe just look at what you all really want, so that we can maybe execute a little more streamlined versus than a whole entire universe. But you all do what you want with your cases. Yes.
Just for clarity, as I understand, the cases are consolidated, and that's primarily for procedural and administrative purposes, but it sounds like the court is looking for almost a joint trial. So I assume that this is probably going to make it to another level of review, and I don't want to get knocked by the Court of Appeals for, joining one of the other petitioners in some way that the Court of Appeals says, well, you didn't present that case yourself. You're a consolidated case, but you still have your own case that you had to present evidence on. Sorry, Mr. Berry, that wasn't presented in your case. I want to try to avoid that while streamlining the process. So I just want to raise that issue up front to make sure that I can, at the hearing, just, look, I adopt Mr. Pierce's argument, I adopt Mr. Hollow, everybody's arguments into mine so that I don't have that issue going on.
Of course. So you all are free to argue for whatever it is that you want on your standalone claims. However, there are broad categories I think that you all want. And so I'm happy to hear from every single person on the writings, but maybe I don't need to hear from every single person on the writings. But if Star Media has something that that their client really wants, then I expect you to present your case in regards to those items that maybe diverge from the broad categories.
Yeah,
Does that make
absolutely.
sense?
Yeah, I was just thinking about the things where I actually agree with everybody on. I don't want to have to present a whole separate thing, but I also want to make sure that that's preserved for me on appeal, because while consolidated for administrative purposes, we're not consolidated for merits purposes, so.
Sure. Well, so that's where your briefing is going to come into play. And, you know, if I have a specific question for Star Media in regards to, you know, their position on something, then you need to be prepared to talk with me about that. Okay? All right. So for the petitioners, we kind of know what we're doing as far as you'll prepare your separate kind of one-offs, but we have kind of our broad categories that we're going to argue. Mr. Pierce, is there a question?
The deeper we get into it, the less I'm understanding about what we're doing. I follow what Mr. Berry said, is that we each have our own case. So if I file a brief, I'll address my particular issues.
Mm-hmm.
Now, previously, Your Honor set forth in detail in an order the progression or the order of presentation. And I assume that would still follow. Maybe not, I don't know. But
Well, we haven't gotten there,
yeah.
you know, as of today. I'm just, you know, for purposes of briefing, if there are areas that everyone has synergies around, you all can work those together. But you all each still need to file your own brief, you know, and if I'm not going to say, Mr. Pierce, you can't come up and address the court on a particular issue, you know, you are in charge of your own case. But I do understand that there are things that you will also have synergies about. So when we think about the order of presentment, which I hadn't got there yet, I was going to speak to the respondents and the interveners first, but when we think about the order of presentment, we all know that when you go on appeal, should this matter go on appeal, it's all about your writing anyway. You know, so your briefing is the most important thing. So put everything that you want me to know about your position in your briefs. You know, you're going to deliver your oral argument, and I may have questions, but the questions are going to come from your briefing because I'm going to read your briefing. So
that all sounds good, but just to follow up, as Mr. Berry said, I anticipate I may say specifically the filing that Mr. Howell made just last week sounded good to me. So I think on that I may have a heading that says this, and I adopt his brief. That's okay with you, Your Honor?
if that's what you want to do, I'm fine with that. But if there's something else that you want to argue as a standalone, just make sure it's in your brief.
Understood.
Okay? All right. I'll hear from the interveners and the respondents. Well, before I hear from you all, we should probably talk about time to update your briefs. So if we are going to go for the 16th and the 17th, and the 17th really is a just extra day in case we need it.
Your Honor?
Yes.
If I may, I think it might be helpful to discuss the content of what the court would entertain before we talk about the timing.
Sure.
If that's possible.
Of course.
So if we may be heard on this first, then I think that might help us then decide what the timing will be, because we'll know what we need to do.
Okay.
May I, Your Honor?
You may.
Thank you. I'm going to step to the podium just Your Honor, again, Eric Osborne for the Covenant School Families. First of all, I really appreciate the colloquy we just had, and we look forward to working with opposing counsel. We've all had a very good relationship in this case, and we will endeavor to work out some of the issues that you've identified. I want to give just a concrete example that sort of was discussed a moment ago. You know, as was noted, Mr. Hammond had a broader request than some of the other petitioners, and that would have included things like pictures of children. Now, in the Court of Appeals briefing, which all of the petitioners were a part of, they specifically said they're not requesting that anymore. And so one thing that I would like to at least float, and I don't know if opposing counsel would agree to this, would be that we might have some sort of, mediation is not the right term, but some sort of gathering of counsel in which, we can clarify what, as you say, what is or is not still being disputed. Because I believe the pictures of children, while technically originally requested, is no longer a part of the case. And I don't want to take my time or this court's time with something that no one is seeking anymore. And so what might make sense would be to have an earlier gathering of counsel and some sort of report back to this court about what is still in dispute. And then from there, we could then have potential briefing. And on the briefing, there are two observations I want to make. One is that my recollection, and I don't have the docket in front of me and it's hard to open on my phone. You'll forgive me for that. But I believe that Your Honor had reset the show cause hearing for July 12th after we had several rounds about whether or not the case would be stayed. And that my recollection is that a deadline for everyone to present evidence had passed. So everyone had fully briefed everything. Everyone had provided all of their declarations and evidence. The case was set. There was nothing left to do. At least that's my recollection. I may be wrong about that because we all agree that a lot of time has passed. There was nothing left to do except show up for the show cause. I'm very happy to have additional briefing if we need it now. But what I would request, Your Honor, is that the evidentiary and factual record, I would say, should be largely set. And so that if there is any additional briefing that takes place, it should be limited to things that have taken place since this action was stayed. And there are things that have taken place. We're all aware of that. And to the extent that has some relevance, then I don't object to petitioners explaining why what has happened since June is relevant and us having a chance to respond to that. But I would think, Your Honor, that it would not be fair to reopen the evidentiary record, which had been fully established and set. And that's why I say I want to raise this issue first before we then talk about what the briefing timing is, because the briefing timing will depend on what exactly is going to be briefed. Is it limited to only what has happened since June to, in Your Honor's words, refresh the case since June, which I think is the proper procedure, or is there something further? And so to summarize, Your Honor, my proposal would be that this court order counsel to gather and come back in a week or two with some sort of agreed agenda about what is actually alive in the case and what's not. And then we can go into a briefing schedule in addition to that, but that would clarify what remains to be briefed and then what will ultimately be argued on April 16th. Thank you, Your Honor. That's what I want to share before we move further.
Okay, give me just a moment. Okay, would anyone else from the respondents like to be heard in regards to what Mr. Osborne has said? Just a moment, Mr. Pierce.
Peter Klett on behalf of Covenant School. Our recollection is what Mr. Osborne represented to the court, and that the presentation of evidence had closed. And we just would point out to the court that we think it would be unfair at this point to have the petitioners, the intervenors have presented their evidence, and now, nearly a year later, have a new deadline for the petitioners to present evidence. They had that opportunity, and they did, in fact, present their evidence to the court. So we would concur with Mr. Osborne's comments that as far as the presentation of evidence, that should have been closed, should be closed.
Ms. Fox? Would you like to be heard on that?
Well, Your Honor, I'll say that the investigation is still ongoing, so there is no new evidence to present to the court.
Okay. Okay. All right. Bear with me just a moment. All right, so at least from the respondents and the interveners, I am hearing that you all have closed presentation of evidence. And Mr. Pierce, this would kind of go back to what I was originally talking about when we think about the original FOIA request, right? Because the way I look at FOIA requests under the law, you're able to make as many open records requests as you would like, but when you come to petition the court about a specific denial, we are kind of talking about a moment in time. So I'd love to hear from you on whether or not we need to reopen anything.
Well, yeah, the requests are in, that's what's being litigated, there's no new requests, so nothing new on that. I just
Okay.
want to clarify, I believe the intervener's recollection about the past orders of the court are incorrect. The order we're talking about is this court's June 12, 2023 order, which did set the show cause hearing as July 12, 13 if needed. So that's consistent with what we're talking about now for April 15, 16, or 16, 17. But right before that date was set, the court, as I pointed out earlier, the deadline was still open for Mr. Hollow to file anything he needed to for his clients. And there was some other open deadlines, and not for me personally, but at the end, right before you set the show cause hearing, you said, quote, any declarations that have not already been submitted to this court are due no later than June 20, 2023. So it was still open for declarations, but not briefing. Now, if the court wants to change that, the court can change that. And I don't have anything new to add based upon our request, which, as the court keeps pointing out, is that's the issue, our past request. However, I have pointed out, and that's consistent with what Your Honor said, maybe things have been stale and we've had this development of this leak. I'd like to be able to address what has happened, what is now out publicly, which previously may have been one of the documents being held in secret. So I do anticipate that something would be filed more than just a brief. It might be something addressing the proof of what has come out since that time.
Okay.
May it please the court with regard to...
Mr. Hollow, can you give me just 1 second?
I'm sorry, Your Honor.
No, you were fine. I'm just having a little technical difficulty up here, and so I want to make sure that I can give everyone my full attention. Okay, Mr. Hollow, thank you.
Thank you, Your Honor. I apologize again for being the apparent fly in the ointment. But with regard to our declarations, which we had not filed because that time had not expired at the time that the matter was placed on hold by the Court of Appeals, I think there's something else that we should be aware of, and that is what I would call exigent circumstances. Because at least 5 to 8 pieces of legislation have been introduced which have as their nexus maybe, or as their origin, or their inspiration, the Covenant School tragedy. And I think that from the standpoint of my client, Senator Gardenhire, when he holds the Senate Judiciary Committee hearings on those pieces of legislation, I know that he feels, and the members of his committee feel, that the information which the Metro has with regard to the shooter's records, what would give us a window into the shooter's soul, would help the legislators form the legislation in a manner that would most clearly, in their opinion, address the salient issues that exist. Remember, we have, I think by estimates, 7 million people in Tennessee. Article 1, Section 1 of the Constitution says everybody in Tennessee is the government. And what we do is we take some of the inherent powers that we have and we give them to the legislature. So we've given some of these powers to the senator here, and to his committee, and to the other members of the General Assembly. And we're going to say to them, now we want you to pass some legislation which will not only be at our request, but will bind 7 million people. And so what we wanted to do, respectfully, Your Honor, was to be able to present that additional dimension to this case, because it focuses, in our opinion, a very real necessity for the full information to come to the legislators, because they're going to be asked to pass bills. And those bills are going to have an effect on 7 million Tennesseans, or some portion of the Senate, maybe just 1 million Tennesseans. I don't know. But, they're going to say, okay, well, let someone do this, or prohibit someone from doing that, or we'll set up this program or that program. But it's so much better. Information is the key, as Your Honor knows. It's the evidence. And the information is the key. And we're being told that there is a reason, a very valid reason, why certain things should be done. But we're not being told why.
Well, Mr. Hollow, we haven't had the opportunity.
I understand.
If you remember when this case first started, frankly, if I had just been allowed to get to final hearing before going up on appeal, we would be finished by now. So unfortunately, or fortunately, we are where we are today, and we just haven't gotten there yet. Not saying that we're not going to get there, not saying that, the analysis is not going to be done and a decision made, but we just haven't had the opportunity to get there. So, with all due respect to the legislators and the legislature, Senator Gardenhire, who is here, the process has not been able to unfold due to, the advocacy of the lawyers in the room. And, whatever legislation is pending up on the Hill, I can't speak to that. But I do know that this court, the parties, no one in this room has gotten past whether or not the decision on intervention was proper. And so now we're back to square one, 8 months later, and moving this thing along.
And we're very appreciative of that, Your Honor, and we certainly recognize everything that Your Honor has said. All of those observations are more than valid. All that I'm saying is that we would deeply appreciate and I think benefit from a declaration or two that would put this additional perspective before the court to give you the opportunity to consider it as part of your decision-making process.
And refresh my memory, at the time that this went up on appeal, did you, because there was an automatic stay from the trial court, you did not go ahead and file what you would have normally filed?
That is correct, Your Honor.
Okay.
I delayed that because the court stayed the proceedings because of the interlocutory appeal.
Right, and frankly, the Court of Appeals told me that I had to stay the proceedings and that I couldn't move on. Well, they are above me, and so I didn't have jurisdiction. So what you're saying is that you did not have the opportunity to fully present your case as you would have. Is that correct? Okay. And Mr. Osborne, you were saying that the briefing has closed.
My recollection was that everything was due, as they said, by June 20th, and that the Court of Appeals did not stay the case till after. But if I'm incorrect about Mr. Hollow, I certainly have no objection was put on the case, particularly to the extent that he wants to file declarations about the importance to the legislature. I would have no objection to that. My concern echoes Mr. Klett's, which is that this court set a very quick deadline that we all hit to put in both briefing and evidence, and we did that, and that to then let others come back and now 8 months later had 8 months to look at our declarations and our expert report and everything. Pick it apart just seems procedurally very, very unfair to me, Your Honor.
Okay.
So that's my primary request, is that I don't want to deprive Mr. Hall of the ability to let the legislature or legislators who might want to give declarations about the importance of the documents from that perspective do that.
That's what we want to do.
And I think we could agree here that if that's the only evidentiary piece left is declarations limited to the importance to the legislature, then, what I would propose is that he be allowed to do that. And again, I go back to, I would also like to just clarify with counsel what's still in dispute. I believe the pictures of the children are not in dispute. I just want to clarify that so we don't waste this court's time or petitioner's time or our time with that. And then I would just propose that we have, if needed, supplemental briefing and a schedule to deal with the issues that have taken place since the stay in late June.
Well, and looking back at my order, it was only the Tennessean, Ms. Wegner, and Senator Gardenhire who had a little bit more time, because Mr. Hollow, I recall that you weren't the original counsel and you came in late to the case.
Yes, Your Honor.
And so, but you did file your reply on, you filed your response on Friday, correct?
Well, actually, I had previously filed a response.
Okay.
Prior to the matter going up on appeal. But then, after the appellate court decision came out, I looked at that decision and I thought, what we really needed, what I needed to do from the standpoint of representing my client was to sharpen the focus a little bit and focus on some of the things that the Court of Appeals considered as part of its decision-making process, which prompted me doing what I did on Friday.
And Mr. Osborne, are you objecting to his, have you had the opportunity to look at his?
Your Honor, I don't recall getting a copy of that. I'm sorry, I haven't read his filing yet, so I'm happy to review that and report back to the court about the objection.
Okay.
I certainly don't object to Mr. Hollow putting in this case. I do recall him filing a brief with this court, as he said. He filed his response in June. So my recollection is the briefing was done. If he still had the ability to file declarations, I don't recall that, Your Honor, but I don't object to his doing so, particularly as we said. Counsel's been working very well together in this case. We all respect each other, and I do not want to deprive Senator Gardenhire of anyone the ability of the legislature to explain why they believe these documents are so important.
Okay.
That's what Mr. Hollow believes is missing.
And Mr. Hollow,
Yes, ma'am.
the only thing that is left from the deadlines that I gave you back in June, other than what you filed on Friday, which may warrant another discussion, but the declarations, that's all you're seeking. Okay, and when might you be able to have those in?
Certainly within less than 2 weeks, Your Honor.
Okay. All right. So what I will...
Your Honor, pardon me, but there was something that did, in reviewing the file, I saw an order of the court that mentioned that the declarations would be filed, and then there was a statement in the order that said cross-examination by declarations will not be permitted, or something like that. It addressed the issue of I think what the interveners are discussing, and that is the cross-examination issue or the presentation of contravailing information. I believe that's in one of the court's earlier orders.
Well, and I think that I probably, you would have to direct me to the date of that order. But, typically there is not live testimony on these cases, and so if there's declarations put in, it's not for the purposes of having kind of cross as you would in a normal trial. This is not a normal proceeding. These open records cases are not. And so any declarations, I did not anticipate having rebuttal to declarations or frankly putting people on the stand to have them subject to cross. This just is not that type of proceeding. So Mr. Hollow, if you could have your declarations, if that is the only thing that is lacking, if you could have those into the court by February 12th?
We can do that, Your Honor.
Okay. You can simply file them under a notice of filing. Okay. In regards to what the salient issues are, if you all can get together and simply submit a notice of filing to the court, if there is anything, and this would be more directed to the petitioners, if there's anything that is no longer in the purview of the court, no longer salient to the discussion, things that you all are, if any, that you would like to waive, which may help narrow the issues, you all can simply do that via a notice of filing, and we can have that in on the same date, February the 12th. Any additional briefing based upon the waiver of issues or supplemental briefing, if you all can have that in by does the 19th work for everyone?
Your Honor, I'd like to propose, I don't know what petitioners think is needed in addition because we thought our case was complete. So I'd like to propose that they would submit a brief first that we could respond to.
Okay.
I think is what Ms. Fox had suggested as well.
Okay, that's fine. So petitioners, if you all have decided to waive any of your issues and then would like to do supplemental briefing based upon any kind of waiver, if you could have those briefs into the court by February 19th. Yes. So, but what I would say is Attorney Hollow is the only one who should really, like when I'm thinking of brand new information declarations, he is the only one, who I'm anticipating a large amount of information from or declarations, because everyone else we're kind of at a snapshot in time. However, if based on any waiver, there's anything else that any additional way you would like for me to look at information, you may present that to the court. And so that's going to be by February 19th. I believe that's what I said. Ms. Fox, would you draft the order?
Yes, Your Honor.
Okay. And then respondents, if you could respond by February 26th. That would be the close of all briefing.
Your Honor,
Yes.
since we wouldn't be having the hearing for another month after that, is it possible we can have 2 weeks?
Of course.
Thank you.
And I just put February 19th on you all. Does that work? I mean, that's 2 weeks from today, maybe a little bit more than that, 3 weeks from today. Generally, are you all okay with February 19th?
Sorry, I might be confused about what briefing you're even talking about.
It's just anything supplemental.
So can I just file my show cause trial brief that we discussed earlier to set forward my legal argument, since it sounds like the show cause hearing we're anticipating now is going to be on briefs. Like, is that what you're looking for?
Didn't you already file something?
Well, the case was stayed, and I understand that the court denied our stay, but the automatic stay should have applied to all the court's deadlines. So I don't particularly want to get into a procedural fight about this. And I don't see how it's going to be harmful for us to be able to present. I mean, I can come here on the show cause hearing date and make my presentation and get it in the record, but it seems like the court would be benefited by our full briefing before we show up on the show cause hearing date.
So, Mr. Bear, you haven't filed anything in this case? You haven't filed a brief?
No, I haven't filed a brief for the show cause hearing.
And you came over from circuit court, correct?
Yes.
Okay.
I planned on making my arguments at the show cause hearing, which didn't occur. It sounds like the court has rethought the approach, which is fine with me if we're going to do it all in briefs, but I want to file a brief if that's how we're doing it.
Just 1 second. Let me look at when you came into the case and when the stay was put down.
Your Honor,
Yes.
I would say that we don't object to his filing whatever briefing he wants to do as long as we have time to respond.
And I'm not going to be introducing new evidence, I just want to make it clear.
Okay. Everyone else has filed a brief, correct? Okay. Okay. All right. So, Mr. Berry.
Your Honor,
Yes.
we're discussing it, and because of the timing, I'm not sure that on behalf of Hammond or the TFA that we filed what would have been a trial brief either last June. So, my entire file with me this morning is this, so.
Okay. Okay, so Mr. Harris,
Yes, Your Honor.
so I see a memorandum. It says Petitioner Hammond and Petitioner Tennessee Firearms Association memorandum in support of petition for access to public records. And that was filed with the court on 6/2/2023.
Would it be okay if we look back at that, because it's been a while, and if we need to supplement that, do it by the 19th?
The only party that will be allowed to supplement their briefing is going to be Mr. Hollow, simply because the stay, and Mr. Hollow, I understand it's declaration only. Is that correct?
That's what we're seeking, please, the court. We have filed a new brief.
But your new brief, and Mr. Berry, I see a brief. Mr. Berry, I see a brief from you as well. So everyone's filed a brief, okay?
Yes, Your Honor, but I understood from your very first comments that we were talking about supplemental briefs about matters, as you said, that maybe had gone stale. And the specific matter that I addressed was the fact that there had been this leak, and that was the number one thing that I wanted to address, is the fact that these particular documents had come out and what effect it has on the overall position in the case.
Okay, so you all are going to get together and inform the court if you're not pursuing certain matters anymore, or if anything in the petitioner's status has changed in regards to the documents that you all are pursuing. You all will do that by February 12th. I will allow a brief supplementation of anything else that you all would like petitioners to bring before the court at that time, with the understanding that you all have already filed briefs, 20 pages, so I do have briefs from you all, but if there's anything else you would like to tell the court in regards to a matter that is you're not pursuing or any new information, petitioners, please have that done by February 12th. Respondents, please have your response to any new information and or supplement by February 26th. And that will be the close of all briefing. Okay? Mr. Hollow, your declarations will be in on February 12th as well. For Metro, the documents that I have, if you could just, if there's anything else that needs to be submitted for in-camera review, anything that would aid the court in reviewing the documents that it has, please submit that to the court by February 12th as well. I will be in trial that day, so Ms. Taylor will be up here with me, but you can just take it to the clerk's office. It's in camera, so just mark it, and I'll have a particular procedure with an order for you to put on top. This order will go on top, and make sure that I get anything additional that I need to be looking at. And then that should be it. Any questions? Mr. Harris? Or
Go ahead. To respond to something that Mr. Berry talked about, you have given us that order of presentation, and that's fine. But I was just asking the court, did the court have some idea right now as to what extent that you would allow or wanted to hear arguments of counsel, the way of opening, closing, or even after that, whether you want any post-trial briefs?
So I haven't given thought to it. Of course, you all can present your cases, open and close. We'll get to post-trial briefs if I feel like I need additional information. I'll put down an order that kind of rehashes the order of presentment now that the interveners are fully in the case. If there's anything that I need to revisit on kind of the order of information, I will make sure that that gets out to you all well in advance of the actual hearing.
Thank you.
You're welcome. Mr. Harris?
Yes, Your Honor, just a housekeeping matter. Last year, you granted a pro hoc order for Mr. Noble, who's my co-counsel.
Mm-hmm.
Apparently, those don't run a full year, they run a calendar year, so it may have expired in
Okay.
December. And rather than boost the national economy by inviting everybody back for a pro hoc motion, could I make an oral motion subject to submitting a new certificate of good standing?
You may. Is there any objection?
Thank you.
Thank you. Yes, sir. I'm sorry, who do you represent?
Yes, Your Honor. Good morning, ma'am. Please, the court. My name is Evan Rothi, counsel for amici curiae in this matter.
Okay,
Just wanted to take up a very brief housekeeping matter, if it pleases the court.
sure. Do you need to, you may approach.
Yeah, I do well.
And I believe that there are several briefs.
Yes, Your Honor. Before the matter was stayed, we filed our motion for leave to file our amicus brief. As far as I'm aware, there was no opposition. There was no opposition before the Court of Appeals in this matter. Just wanted to ask, Your Honor, it was set for hearing concurrent with the show cause hearing previously. If there is no opposition to streamline matters at that show cause hearing, we wanted to ask the court's preference as to whether we could take that up on order or if we should proceed with that same plan to set the hearing for that show cause hearing date.
And when were you, I'm sorry, who were your clients?
We represent the independent schools in this matter, Franklin Road Academy, Montgomery Bell Academy, Oak Hill School, and St. Paul Christian Academy.
Can you tell me when you filed your order?
Yes, Your Honor. We
Or your
filed on
request?
June 12th, 2023. I believe it shows up in the docket as motion for leave, and then our amicus brief is Exhibit A to that motion for leave.
And you said it was on June 12th?
Yes, Your Honor. That's the date we filed.
Was it maybe on June the 8th? There's I see it. I'm
Stamping,
sorry.
yeah, sorry
There
about
are
that.
two. There was one on June 8th and one on yours.
And that may be the amicus brief filed by, I believe, District Attorney Glenn Funk. I do not represent him. I represent the other amici.
No, this is someone different.
Someone different. Oh.
Okay.
And Your Honor, we just want to streamline matters for the court, and we just ask your preference as to whether we'd like to take that up on a hearing in advance of the show cause hearing, at the show cause hearing, or if a hearing is even needed on our motion for leave to file the amicus brief.
Well, since I have all counsel here, do I have any opposition to the filing of an amicus brief on these independent schools? Have you all had an opportunity back in June to look at this information?
No opposition.
No opposition on it.
None.
Brewer does not object.
No opposition here, Your Honor.
No opposition.
Would Your Honor like us to draft an order? Would that be helpful?
Yes, please draft the order and file it, and I'll get it signed, and then you can come with everyone else.
Thank you, Your Honor. I appreciate
Thank
it.
you. All right. Any other business before the court? Yes, sir.
Just a related question, as Mr. Robbins said, the district attorney filed an amicus brief as well. Obviously, there's no one from the DA's office here. Should we try to do anything in that regard, or just leave it at the DA's office to?
Well, so there's another amicus. Is anyone here on behalf of John Thompson? Okay. You know, for the others who have filed motions for leave to file amicus, I will leave it up to them to do their jobs.
Thank you.
Okay? All right. Ms. Fox, if you would prepare the order. As I said, we will come back here on April 16th and 17th at 10 a.m. To hear argument on this matter. Okay? All right. Thank you all so much. We are adjourned. Thank you.